안녕하세요. 지금부터 코참 2020년도 법률 세미나를 개최하도록 하겠습니다. 저는 이번 세미나 진행을 맡은 코참 이사이자 청년분과위원장인 고수정 변호사입니다. 온라인으로 인사드릴 수 있어서 매우 영광입니다. 이번 법률 세미나는 100% 온라인으로 약 1시간 반 정도 진행 및 녹화되며 향후 코참 파일에 저장될 계획입니다. 가능하시다면 끝까지 세미나에 참석해 주시면 매우 감사하겠습니다. 이번 세미나를 준비하기 위해서 코참 회장단을 비롯해서 강연을 준비하신 연사님들과 관련 법무법인 변호사님들과 직원분들께 감사의 말씀을 전합니다. 본 법률 세미나는 크게 두 가지 주제로 나눠져 있으며 각 연사분들께서 사전에 영어 또는 푸어로 발표를 녹화해 주셨습니다. 발표 이후에 질의 시간을 간단히 갖도록 하겠습니다. 사전에 채트볼드에 영문으로 질문을 보내주시면 연사님들께서 답을 하시는 데 도움이 되겠습니다. 그럼 연사님들의 이해를 돕기 위해서 제가 간단히 푸어로 설명을 드리도록 하겠으니 회원분들의 양해 부탁드립니다. Boa tarde. Vamos dar início ao nosso seminário jurídico online 2020. As principais atualizações jurídicas da LGPD e Covid-19, seminário este organizado pela Kocham, Câmara de Comércio Brasil-Coreia. Meu nome é Sujun Ko e eu sou diretora e presidente da Comissão de Jovens Profissionais da Kocham. Gostaria de agradecer a todos os membros da diretoria e palestrantes, bem como os colaboradores dos respectivos escritórios de advocacia, escritórios estes que são os associados da Kocham, para que pudéssemos preparar o presente seminário jurídico. Nosso seminário será dividido em dois grandes temas, em que cada palestrante fará a apresentação previamente gravada e em seguida faremos Q&A. Este seminário será gravado e registrado no arquivo da Kocham para que os outros possam acessar ao conteúdo posteriormente. Aos participantes, pedimos que deixem os comentários ou perguntas no chatboard, se possível em inglês, para que possamos endereçar aos palestrantes. Aos palestrantes, pedimos que respondam as perguntas ou comentários, se possível em inglês, para que possamos otimizar nosso tempo. Caso necessário, iremos reforçar as respostas em coreano, no sentido de auxiliar os participantes. 그럼 연사님들의 발표에 앞서서 김승주 코참 회장님의 인사말을 듣도록 하겠습니다. Antes da sequência no nosso seminário, vamos ouvir as palavras de boas-vindas do presidente da Kocham, Sr. Sung-ju Kim.
안녕하세요. 코참 회장 김승주입니다. 코로나로 모두들 좀 어려운 시기를 겪고 계실 듯한데 저희 코참에서는 그런 시기에 조금이나마 기업 여러분들께 좀 도움을 드리는 자리를 제공하고자 처음으로 이제 온라인 법률 세미나를 준비했습니다. 준비하는데 이제 우리 청년분과위원장님이신 이제 고수정 변호사님께서 많은 고생을 해주셨고, 그 다음에 이제 다른 코참 임원들께서도 수고를 많이 해주셔서 감사드리고요. 특히 세미나 진행을 준비하신 로보히조, 도지니, 데마레스치 변호사님들께 특히 감사의 말씀을 드립니다. 본 세미나를 통해서 우리 회원사 여러분들의 사업에 좀 도움이 되는 유익한 시간이 되길 바랍니다. 감사합니다.
회장님 감사합니다. 그럼 이제부터 연사님들의 발표를 듣도록 하겠습니다. 먼저 개인정보보호법에 관련해서 로브데히조 법무법인 대표 변호사님이신 셀주 바렐라 브루나 변호사님께서 발표해 주시겠습니다. 발표 준비에 지원해주신 조인혜 변호사님께도 감사의 말씀을 드립니다. Vamos então dar início às palestras. A primeira palestra será sobre a Lei Brasileira de Proteção de Dados, LGPD, Lei número 13709 de 2018, preparada pelo advogado Sérgio Varela Bruna, sócio do Lobo de Riso Advogados. Em seguida, vamos abrir para Q&A, onde Sérgio poderá responder diretamente às perguntas. Aproveito para agradecer a doutora Inês Cho, que nos auxiliou com a preparação desta palestra.
Good afternoon, ladies and gentlemen. I would like, first of all, to thank the invitation of Kocham to talk about the Brazilian data protection law, the LGPD. It's a great honor for us to be here and to talk to you about this matter. I have a presentation, so just let me show you and we'll get much more easy to follow the presentation or the explanation. A little information about me. My name is Sérgio Varela Bruna. I am a partner to Lobo de Riso, and I'm responsible for the regulatory and competition law practice of the firm. I've been working with data protection matters for a number of years already. I'm here today with Inês Cho. Inês is a partner in the corporate and M&A practice. She and I will be here to answer your questions. It will be a pleasure if you have any questions, any doubts regarding the LGPD on how to get your companies in compliance with the new law. Lobo de Riso is a full-service law firm. We basically cover all the areas where our clients may need legal support in running their businesses. And these are the main areas which we have in our firm. So let's go to the LGPD. The LGPD came into force only on September this year, but it was enacted back in 2018. It is a law that deals with privacy and the protection of personal information of individuals. The information that is covered by the LGPD is individual information. It is not company's information. So it's important to bear that in mind from the beginning. Any company processes information, as you see. So this law will impact virtually all companies in the country, because any company which is operational has and uses information from individual persons in their activities. The basic rule of the law is that companies may only process personal information if the company has a legal basis, that is, a legal authorization for the processing. I will talk a bit more in detail about legal basis, but let's first talk about what is the type of information we are dealing with and what processing means. So you will find on the bottom of this slide a translation of the wording that the law uses to define processing. And you will see that processing is anything. So processing is any operation carried out with personal data, such as collection, production, receipt, classification, use, access, reproduction, you name it. Anything that you do with personal data is processing. Even just storing personal data without actually using it. So anything is processing. And personal data, in turn, is defined as the information regarding an identified or identifiable individual. So it's either an information that links to an individual whose identity is known, or the information that, although not identifying that individual, can be used for the identification. So even if the identification is not obvious, is not expressed, if you can use the information to get the identity of the person to whom the information is related, then this information is personal also. So any processing of personal information requires legal basis, as I was saying. And what should be regarded as legal basis? These are the legal bases provided for the LGPD. The main and most remembered one is consent. Consent is defined by the law as free, informed, and unambiguous manifestation of will, whereby the data subject agrees to her or his processing of personal data for a given purpose. Please remember, the legal basis is always linked to a specific purpose. So if you have legal basis for a particular purpose, you might not be able to use that information for a different purpose, okay? Unless you have another legal basis. So consent is the permission by the data subject for the use of his or her information for a particular purpose. Consent is the most remembered legal base, but it might not be the best one, at least for companies, because consent can be withdrawn. So if an individual is able to consent with the use of his or her information, he is also entitled to take consent back. And if consent is withdrawn, then the company will no longer be able to use the information for the purposes that the information was used. So there are other legal bases that likewise entitle companies to process personal information other than the data subject's consent. There is one that is meant for the compliance of legal or regulatory obligation. And so if a company is required to do something under the law with the information, then the company has the legal basis to do it. Companies may also use information to make credit assessments and to inform credit protection databases of transactions with individuals. So that is another authorization that the law brings for the processing. There is a very broad and vague authorization for companies to use information when they have a legitimate interest in the use. It is very broad, but the law also requires that this legal basis is used with caution, because companies have additional obligations when they are using this legitimate interest database. Oh, sorry, legal basis. You may use information whenever that is required to protect the life or the physical safety of the individual. You may use information when the information is necessary to enter into an agreement with the particular individual that will enter into the agreement with you. You may also use information to defend your interests in judicial and administrative or arbitration procedure. And there are also other legal bases that are more meant for research and government. So government has, and that is here and below in this box, the legal authorization to use personal information to perform public policies. There's also possibility to use personal information for study and research and the protection of health. So companies also have to grant individuals, data subjects, with the new rights that are granted to them by the law. The new rights are these, basically, the individual has the right to ask confirmation of the existence of the processing, has the right to access the data that is being processed, has the right to ask correction, the correction of data that is mistaken, is wrong, has the right to require the blocking, the deletion, or even the anonymization, so the elimination of the features that enable one to identify the person that is related to the data, whenever the data is unnecessary or excessive in relation to the purpose of the processing. The individuals have the right to data portability. So like what happens with phone numbers, nowadays you can migrate your phone number from one operator to another operator and keep the same number. Similarly, data subjects will be entitled, or are already entitled, to ask a particular company to transfer his or her personal information to another company, so that the company uses that information on behalf of the individual, or in the interest of that particular individual. Individuals can require the erasure of their data. They can ask companies to identify which entities with which the data controller has shared that individual's information. The individual has the right to be informed of the possibility of denying consent and which would be the consequences thereof. So if, for instance, if an individual is is required to provide information in a website in order to use a service that is offered by the website, the website should inform the individual that if consent is denied, then the person might not be able to use the services. The possibility to withdraw consent is also a right of individuals under the LGPD. And companies have obligations in respect of the legal data protection regime. So the companies are under obligation to inform data subjects of the data processing if they start processing someone's information. The company must keep records of the processing operations. The The company must disclose the identity of the company's data protection officer. In Brazil, the data protection officer is called by a much less fancy, so to speak, word, which is the encarregado. But the functions of the DPO and the encarregado are similar. So we are usually translating encarregado by data protection officer. The company is under obligation to inform security incidents that happen to data subjects and to the data protection, the Brazilian Data Protection Authority, the ANPD. The company should adopt technical and administrative security measures against unauthorized access to the information. Companies are also required to educate and train employees and third parties about personal data protection. And finally, the company is required to receive and reply the complaints presented by data subjects or the ANPD, the Brazilian Data Protection Authority. What are the risks for not complying with the law? The main and most immediate risk is reputation. So if there is a security breach, the company might be involved in a public scandal. For instance, I remember a couple of years ago, maybe a little more, but there was, I think there's still a company called, I think, Ashley Madison, which was running a website, a service of date matching. But the date matching that the company was running was meant for married people. So there was a data link, and those that were, seeking the dates in that particular services had their information disclosed to the public. So in that particular situation, there was a huge, I would say, risk of damage for the people that were using the service. And there was a lot of press coverage about that. Obviously, it was very interesting for the public, such a data link. So the company, when is involved in a public scandal like that, is damaged in its reputational and in its image immediately, no matter if the company is innocent or not. The exposure is immediate. There are also fines that can be significant. Fines can go up to 2% of the turnover of the company in the previous fiscal year, or 50 million, whichever is the highest amount. So that is significant anyway. And the grounds for avoiding liability are very narrow. So there are only 3 situations where the company can avoid liability, and those are by proving that the company did not process the data related to a particular loss, that the processing, that's the second possibility, was made in compliance with the LGPD, and finally, the company may claim that the damage was caused exclusively by the data subject with no participation or involvement of the company. Otherwise, the company will answer for losses caused by the security breach. So what companies need to do and in order to be compliant with the LGPD? So the first thing companies need to do is to map out the situations where the company is processing personal data. So where are the places in my company where I can find data, personal information? Personal information, unfortunately, is everywhere. So from the reception of the company, where receptionists take note of the names of visitors, the persons who they are visiting, the place they came from, their phone numbers, whatever, their ID numbers, those are personal information. So from the reception to other departments, so such as human resources, any company has information about its employees. It has information about the children of the employees for providing health insurance coverage, for instance. The financial department will have information about the contact persons in other companies, in banks. The marketing department will have information on the customers, on the clients, on potential customers. So information is everywhere in the company. So, and the company needs to identify which information it has and what are the uses that the company makes with that information. So the mapping out is the first step. Afterwards, the company needs to establish whether there is legal basis for the use of the information, for the processing of the information. It should review security measures because the company is responsible for the security of the information. And the company should make records of everything in the development of this project. So the company needs to store records of the decisions and the verifications that are made during the whole process. And in this digital repository that we usually call it, the company should answer questions like these. What kind of data is collected? Who is the data subject? And what is the purpose of the collection? How will the data be processed? Where will the data be transferred to? And who will receive it? What is the legal basis for each step of the processing? Where and for how long will the data be stored? Who can access such data? Are there appropriate security measures? Have risks been mitigated? Is the processing limited to the purpose of the collection? So questions like these should be answered, and the answers recorded in documents that will be finally stored in this digital repository. The digital repository will serve as proof that the company made a reasonable assessment and took sound decisions regarding the data processing. After you complete your review, you will have measures to be taken. You have new policies to be implemented. So you should put your hands in the work. So you should implement the measures that you've planned. And you finally need to educate your personnel, educate your employees about the value of data protection and make them aware of the measures that they need to take if they are required to do so. So it's like a Grand Prix. You should start a project, and this project is not a legal project. It's a project that the company needs to run, as many other projects that the company usually has. So the first thing to do in any project is to define a project leader, and this project will require a working group, because there are, as we saw, there are many departments of the company that have personal information. So you will need to have people that know the use that is made with the information to participate in the project and bring solutions and suggestions for the processing of the information or the identification of legal basis. You should set up a budget for the project. The project will require investment. Then you should, structure a plan, an action plan, approve your budget, and then start mapping out the data. So when you start mapping out the data, you're already here in the corner 6 of our Grand Prix. You will map out the data by identifying the categories of data, the purpose of the processing, the data flows, where the data is coming from and where it is going to. Identify your security measures, the contracts with third parties that receive or transfer information to you. So you should amend many contracts in order to have appropriate provisions to protect your interest in connection with data protection. You should identify your policies, adapt them, create new policies as necessary. You should, identify legal bases and risks. So this is the mapping out. And finally, you need to implement your actions. So you should eliminate the data which is not necessary. You should secure legal bases. If you don't have them, you would be required to take action to obtain the legal basis. You should improve your safety systems. You should organize the records of the processing, and you should build this digital repository that I mentioned. Review policies, review agreements, train your personnel, train your employees, and then finally you should monitor and update your program. It's like a building. First you prepare the land, then you build the structure of the building, and when the building is done, you need to maintain it. You need to keep everything operating perfectly, and you should update the systems and the procedures that you've created as necessary to keep everything up to date and in compliance with the law. Once again, I would like to thank you for the opportunity of talking about the LGPD. And as I said, we will be glad to answer questions that you may have. If you have any doubt, please let us know. It will be a pleasure for us. Thank you very much.
세르주 변호사님의 발표 감사드립니다. 이어서 간단하게 질의 시간을 갖도록 하겠습니다. 연사님께서는 답변을 영문으로 해주시면 감사하겠습니다. Obrigada pela apresentação, Dr. Sérgio. Eu gostaria agora de abrir para Q&A. Pedimos para que o palestrante responda em inglês, se possível.
I'll first read the answer, the question that was made by Fabio Schalk. Even a simple internal publication by the company of the birthday or the month would be subject to such legislation. Considering that in such publication we inform the month and the date of the employee's birth, we just do not inform the year. Thanks in advance. Okay. Yes, provided, I would assume that this information would only be useful if the person is identified. So you would say the name of the person and the date of the birthday. So you can link the information to the name, to the identity of the person. So that is also subject to data protection. As for employees, the problem is not very big, because one of the things that the company needs to do is to adapt the labor or the employment agreements that are in place in the company. And the employment agreement would include a data protection provision whereby the parties will agree that the information of the employee can be used for certain purposes, and also a consent form. In the consent form, the employee will say that he or she consents with the use of the information for things that are not covered by the compliance with legal obligation, legal basis. For instance, it is a fact that the company is required to use the employee's information in filing certain reports to the government, but not to make an agreement with a health service operator or insurance company to provide health insurance coverage to the employees. So the employee will consent that the company uses the information to those things that are not covered by legal obligations, but still are in their interests, both of the company and of the employee. And the use of the disclosure of the birth date, it is certainly something that would be covered by the law itself. My pleasure. You are on mute too.
Obrigada, Dr. Sérgio. Então, vamos continuar. 다음은 팬데믹 이후 노사 관계에 대해서 토시니 프레이리 법무법인 대표 변호사님이신 알레šan드르 데 아우메이다 까르도수 변호사님께서 발표해 주시겠습니다. 발표 준비를 지원해 주신 김신재 변호사님께 감사의 말씀을 전해드립니다. A próxima palestra será sobre principais tendências nas relações trabalhistas no período pós-pandemia, agora com o advogado Alexandre de Almeida Cardoso, sócio do Tozzini Freire Advogados. Aproveito para agradecer à doutora Xin Jaikin, que nos auxiliou com a preparação desta palestra.
Boa tarde a todos. Agradeço o convite feito pela Kocham, apresentação a respeito do cenário trabalhista no período de pandemia e sobre as principais tendências da área, né? A gente começa falando a respeito deste ano, um ano bastante atípico sob diversas perspectivas, inclusive em relação à área trabalhista, né? Aqui eu retroajo ao mês de março, quando nós começamos a receber medidas de isolamento social e medidas restritivas ou até mesmo que impediam o funcionamento de diversas atividades empresariais. E essas medidas de isolamento e de restrição de atividades trouxe mudanças forçadas e muito acentuadas nas relações empregado-empregador. Muitas empresas, por exemplo, que sequer tinham política de home office, do dia para a noite, elas viram nesse home office a única alternativa de manter as suas atividades, porque não fosse o home office, elas teriam que fechar as portas, né? No início de abril, começaram a surgir as primeiras medidas emergenciais por parte do governo, algumas criando novas alternativas, como a possibilidade de antecipação de férias, e outras, digamos, flexibilizando regras que já existiam na legislação trabalhista. Então, regras mais flexíveis para concessão de férias coletivas para todos os empregados, um banco de horas mais extenso, com um período de vigência maior, para que as horas não trabalhadas pelos empregados neste período de retração das atividades pudessem ser repostas em até 18 meses, a partir de janeiro de 2021, e principalmente regras que facilitavam o teletrabalho, também chamado de home office. Tivemos uma segunda medida emergencial que tratava da suspensão dos contratos de trabalho e da redução da jornada de trabalho com redução proporcional de salários. Em ambas as situações, com o pagamento de um benefício emergencial por parte do governo federal. Essas duas medidas, tanto de suspensão quanto de redução da jornada, elas foram mais efetivas em relação às empresas, porque elas traziam uma economia imediata na folha de pagamento, que tradicionalmente é uma das despesas mais expressivas da atividade das empresas, né? Nós tivemos também empresas que consideraram que essas medidas emergenciais do governo não foram suficientes para atender às circunstâncias pelas quais elas passavam, e essas empresas buscaram caminhos diferentes. Os dois principais foram a negociação coletiva e a negociação com os chamados empregados hipersuficientes. Em relação à negociação coletiva, essas empresas recorreram à negociação tradicional com o sindicato, porque a negociação com o sindicato ela já tem uma previsão na lei, ela oferece uma segurança jurídica bastante grande, que o que se negocia com o sindicato, inclusive flexibilizando alguns direitos trabalhistas, é possível desde que haja a aceitação por parte do sindicato. E a outra alternativa que eu mencionei é a negociação direta entre a empresa e o empregado chamado de hipersuficiente. Esse empregado hipersuficiente, ele surge com a reforma trabalhista que tivemos em 2017, e que é aquele empregado que ele tem diploma de nível superior e que ganha acima de aproximadamente R$ 11.200 por mês. Para esses empregados hipersuficientes, a lei trabalhista passou a permitir uma negociação direta entre esse empregado e a empresa, sem a participação do sindicato, e o que esse empregado negociar em seu interesse prevalece, inclusive, em relação ao que o sindicato negociou para os demais empregados, em algumas circunstâncias pode prevalecer em relação até ao que está previsto na lei trabalhista. E por isso é uma alternativa bastante interessante que foi largamente utilizada nesse período de pandemia, principalmente nas situações em que não era possível estabelecer uma negociação com o sindicato representativo dos trabalhadores. Aí, depois desse breve resumo a respeito do contexto da pandemia, me parece que a discussão que pode ser mais interessante num foro como esse é entender um pouco quais são as tendências para o mercado de trabalho e das questões trabalhistas mais relevantes, né? Eu até colocaria de uma forma um pouco diferente. Qual o legado desse período de pandemia e quais são as principais tendências para a área trabalhista? Nós sabemos que ainda não saímos desse período de pandemia, ainda enfrentamos uma situação ainda bastante delicada em nosso país. Há também uma preocupação grande de uma segunda onda desses contágios, mas, de qualquer maneira, o que nós sentimos dos nossos clientes já é um olhar voltado para o futuro. Como eles pretendem desenvolver as suas relações com seus empregados já no período pós-pandemia, né? Aí nós temos uma discussão muito interessante minha com os meus sócios trabalhistas aqui do escritório. Nas nossas conversas, nós temos dito que esse período de pandemia não é apenas um período de retração de atividades empresariais, com muitas dificuldades e desafios para a preservação das relações empregatícias. Nós dizemos que a pandemia será um novo marco com mudança de diversos paradigmas nas regras, nas concepções dessa relação entre empregado e empregador. Eu posso citar alguns exemplos para exemplificar, para ilustrar o que eu estou dizendo. O primeiro deles, e mais discutido nesse período de pandemia, é a questão do home office. Muitas empresas sequer tinham política de home office até a pandemia e se viram forçadas a criar uma política de home office como única alternativa para a manutenção das suas atividades. Até a pandemia, o percentual de empresas que praticavam o home office era pequeno e era dado uma importância, digamos, ainda pequena para a questão do home office. Com a pandemia, as empresas praticaram largamente o home office e se valendo das regras que existem lá na nossa legislação trabalhista. Mas o uso por muitas empresas desse home office acabou trazendo discussões que nós até então desconhecíamos. Então, por exemplo, a questão da responsabilidade do empregador pelo reembolso de todas as despesas necessárias a uma estrutura que o empregado precisa ter para desenvolver o trabalho em home office. Se a empresa quer que ele trabalhe em home office, mas ele não tem uma cadeira adequada para trabalhar, uma mesa adequada para trabalhar, quem tem que arcar com o custo dessa compra? É a empresa ou é o empregado? Pelas regras atuais, isso tem que ser objeto da negociação entre o empregado e o empregador sobre quem arcará com esse tipo de despesa. Mas hoje já há discussões maiores a respeito desse tema, se entendendo, por exemplo, que a empresa deve arcar com todo e qualquer tipo de custo, de estrutura que o empregado necessite para desenvolver o trabalho em home office. A mesma coisa em relação às despesas permanentes, como, por exemplo, a assinatura de uma internet para poder desenvolver o trabalho remoto. Hoje faz parte das regras que venham a ser estabelecidas entre o empregado e o empregador no aditivo contratual, mas já há quem diga que isso necessariamente é uma despesa da empresa, né? Como fica a questão do controle de jornada? O empregado que trabalha em home office, ele tem horário para começar a trabalhar, horário para terminar, horário de intervalo para refeição. Então, pela regra atual, esse empregado não está sujeito a um controle de jornada, mas também há, inclusive, projetos de lei no Congresso Nacional, entendendo que, se não para todos, mas para uma boa parte desses trabalhadores, deve haver, sim, algum tipo de controle de jornada para que esse empregado não trabalhe nas jornadas normais, além de 8 horas por dia e que possa usufruir daqueles intervalos que a legislação trabalhista estabelece. Há também uma preocupação muito grande sobre a questão da ergonomia, se esse empregado ele está sendo devidamente orientado e acompanhado em relação a todas aquelas questões que envolvem a sua saúde, não é? Então, estou falando aqui de um ambiente em home office que esteja equipado com uma mesa e uma cadeira apropriados, que tenha uma iluminação adequada, que tenha uma ventilação adequada, que são as mesmas regras que hoje as empresas são cobradas nos seus estabelecimentos. Eu diria que a tendência dessas discussões que a gente tem acompanhado, algumas propostas até em trâmite no Congresso Nacional, é justamente nesse sentido, de que seja transferido para o home office as mesmas regras de proteção que hoje existem para o trabalho desenvolvido no estabelecimento do empregador, né? Uma outra tendência muito forte, não é novidade, mas que tende a se acentuar, é a questão das negociações coletivas. Por quê? Porque a negociação coletiva é um caminho seguro para que sejam estabelecidas, por exemplo, políticas de remuneração com menos foco no salário fixo e uma porção mais expressiva na parte referente à produtividade, à performance do empregado. E o caminho mais seguro para o estabelecimento dessas regras é a negociação entre a empresa e o sindicato que representa esses trabalhadores. Um terceiro tópico que me parece uma tendência muito, muito relevante nesse período pós-pandemia é a questão relativa à gestão de pessoas. O que eu quero dizer com isso? Que hoje a importância que se adquiriu por conta das circunstâncias do período atual, não só da pandemia, mas também com todas as discussões de caráter social, de caráter humanitário, de responsabilidade social, nós notamos que hoje as empresas elas são cobradas por muito mais do que aquilo que está expressamente estabelecido na lei. Então, eu vou dar um exemplo do que eu quero dizer com isso. Então, hoje nós temos na lei uma cota que as empresas devem cumprir em relação a empregados portadores de deficiência. Se a empresa não cumprir essa cota, ela está sujeita a uma série de penalidades, ações judiciais, etc. O que eu quero dizer é que quando se fala hoje em diversidade, quando se fala hoje de inclusão, o que se espera, o que se cobra das empresas é alguma coisa muito além do que, por exemplo, a cota de empregados portadores de deficiência. Hoje há um acompanhamento muito de perto por parte das autoridades trabalhistas em relação, por exemplo, ao equilíbrio entre os empregados, um equilíbrio de gênero, se há um número compatível de homens e de mulheres na empresa, se a empresa ela se ocupa da inclusão de minorias, e minorias as mais diversas, né? Então, estamos falando aqui do público LGBTI+, né? De trabalha pessoas com orientação sexual, de lésbicas, gays. Muitas vezes essas discussões alcançam, inclusive, o problema dos refugiados, a questão também da inclusão racial, sobretudo das pessoas de descendência negra. Então, são uma série de discussões que não há uma previsão específica de cota como acontece em relação ao portador de deficiência, mas que se a empresa ela não der a devida atenção e tratar com muito cuidado desses temas, ela pode no limite, inclusive, sofrer acusações de adotar políticas e práticas discriminatórias em relação a essas minorias, né? Quando eu falo também de gestão de pessoas, eu também me refiro hoje a uma nova preocupação das empresas quanto à proteção de dados pessoais dos empregados, em função da nova Lei Geral de Proteção de Dados, que exige uma série de cuidados na administração de informações dos seus empregados, que até julho deste ano não existiam, porque a lei entrou em vigor a partir de agosto. Há também uma preocupação diferenciada em relação à preservação da saúde e bem-estar do trabalhador no ambiente de trabalho. Nesse período nosso em que a Covid-19 ainda é um problema, hoje é exigido das empresas que tomem medidas necessárias a se evitar o contágio da Covid no ambiente de trabalho. E se a empresa não tomar esses cuidados, ela corre o risco de que os empregados infectados tenham a sua doença classificada como uma doença ocupacional. A partir do momento que a doença é classificada como ocupacional, isso tem um efeito jurídico completamente diferente, porque depois que esse empregado voltar do afastamento, ele terá uma estabilidade no emprego de pelo menos 1 ano. Então, vejam como é importante a empresa cuidar da preservação da saúde dos seus trabalhadores, sobretudo em tempos de Covid, né? E um último item que eu gostaria de fazer menção, ainda em relação à questão da gestão de pessoas, é toda uma preocupação que nós notamos em relação às autoridades trabalhistas quanto ao tema dispensa de empregados. Nós sabemos que o número de trabalhadores desempregados aumentou em razão da pandemia, e o que nós notamos é que já há toda uma movimentação das autoridades, especialmente do Ministério Público do Trabalho, para evitar que o país passe agora por uma onda de dispensas em massa, dispensas coletivas em grande escala. Então, por exemplo, o Ministério Público do Trabalho, ele acaba de soltar um documento em que ele expressa o entendimento dele, Ministério Público do Trabalho, sobre todas as restrições que hoje existem e não existiam no período anterior à pandemia, para que o empregado ele faça uma dispensa coletiva na sua empresa. Então, a preservação dos empregos, ou mesmo se a empresa notar que tem necessidade de reduzir o seu quadro e efetuar uma dispensa coletiva, hoje ela tem que conduzir esse tema com muita cautela, com muito cuidado, porque nós notamos exatamente o que eu mencionei, tanto uma atuação fiscalizadora muito forte por parte do Ministério do Trabalho e do Ministério Público do Trabalho, como uma tendência de que a Justiça do Trabalho também adote uma postura bastante restritiva em relação à possibilidade dessas dispensas, com riscos, por exemplo, de decisões judiciais que determinem a reintegração de trabalhadores ou até o pagamento de indenizações adicionais. Eu poderia aqui citar uma série de outras tendências que nós enxergamos, mas eu não quero aqui ultrapassar muito o tempo que me foi concedido, então eu encerro por aqui. Agradeço mais uma vez o convite feito pela Kocham e fico à disposição de todos para qualquer tipo de esclarecimento. Muito obrigado.
알렉산드리 변호사님의 발표 감사드립니다. 이어서 간단하게 질의 시간을 갖도록 하겠습니다. 연사님께서는 답변을 영문으로 해주시면 감사하겠습니다. Obrigada pela apresentação, doutor Alexandre. Agora gostaria de abrir para Q&A. Eu peço que o doutor Alexandre responda em inglês, se possível. Acredito que você tenha recebido algumas perguntas. Se você puder ler a pergunta e responder. Eu vou ler aqui.
Isso.
Tá, eu vou ler aqui. When people work at home, you said the company needs to pay all the costs. Is it necessary or negotiable between company and employee?
Okay, today, according to the law, this issue is negotiable between the company and the employee. So it's advisable that the company and the employee they register this provision in an amendment to the employment agreement. If the cost related to home office will be sponsored by the company or the employee. What I said is that there is a trend that for the future, and the recent Bill of Rights saying that all the costs, all the expenses related to the home office must be sponsored by the company, but taking into account what is provisioned in the law today, it's something negotiable between company and employee to be formalized in amendment to the employment agreement.
Obrigada, doutor Sérgio. Ai, desculpa, obrigada, doutor Alexandre. Então, com isso, a gente vai passar para a próxima palestra. 마지막으로 팬데믹 이후 세제 및 사회보장 기타에 대해서 데마레스트 법무법인 대표 변호사님이신 도글라스 모타 변호사님께서 발표해 주시겠습니다. 발표를 준비하는 데 지원해 주신 김민곤 변호사님께도 감사의 말씀을 전합니다. A próxima e a última palestra será sobre os principais aspectos tributários durante 2020, com o advogado Douglas Mota, sócio do Demarest Advogados. Aproveito para agradecer Dr. Min Kon Kim, que nos auxiliou com a preparação desta palestra.
안녕하세요. 브라질 법무법인 데마레스트의 기업 인수합병에 근무하고 있는 김민곤 변호사입니다. 1948년 설립된 데마레스트 법무법인은 풀 서비스를 제공하고 있으며 브라질뿐만 아니라 라틴 아메리카에서도 최고의 로펌 중 하나로 손꼽히고 있습니다. 70년 넘게 브라질 법률 시장에서 최고의 로펌으로 자리매김할 수 있었던 비결은 저희 로펌의 각 구성원이 좀 더 차별화되고 좀 더 효율적인 법률 서비스를 고객에게 제공하고 있어서 그렇다고 믿습니다. 저희 로펌은 현재 350명에 달하는 최고의 탁월한 변호사 구성단을 갖추고 있으며 상파울루, 캠피나스, 히우자네이루, 브라질리아, 뉴욕에 직영사무실을 두고 있습니다. 또한 15년 가깝게 코리안 프랙티스 그룹을 운영하고 있는데요. 한국의 문화와 비즈니스가 좀 특별하다는 모든 것을 이해해서 이에 맞는 통합형 법률 서비스를 제공하고 있습니다. 오늘 부디 좋은 강연을 가지시길 바라며 저희 파트너 도글라스님을 이어서 강연을 진행하게 되겠습니다. 감사합니다.
Hello, everyone. I'd like to thank Kocham for having me today in order to speak or to make a presentation regarding the taxation in Brazil, the tax system in Brazil, one of the most complex tax systems in the world. In view of that, my presentation will cover some important points. At the beginning, I present an overview of the Brazilian tax system. Second, main issues of the current tax system. I will introduce 3 different projects regarding the tax reform in Brazil, the most important issue discussing during this year of 2020, because it's a very important issue here in Brazil, and maybe because the tax government, the federal government is using this project as one of the most important targets for this year or next year. Additionally, I will present a chart involving tax matters adopted by the government during this year, during this COVID contest. After, I will talk a little about social security measures adopted during this year as well. And at the end, I will comment some very important decisions rendered by the Supreme Court in Brazil during this year. And why it's important to comment, because during this year, considering the impossibility of having regular sessions, the Supreme Court decided to make some virtual sessions, and because of this, a lot of decisions were rendered during this year. So at the end, I will comment this. So considering the idea of discussing or commenting some tax issues in Brazil, it's very important to understand how Brazilian tax system or the Brazilian tax system works. Why? Because the tax system in Brazil is very complex due to the fact that we have 3 different levels of taxation in Brazil. It's important to remember that the Brazilian Federation is not necessarily equal to the American Federation. There are some specific issues, there are some differences, and it's not possible to compare with the American system, mainly because of the independence of the states. Here, the states has less power to guide some issues. Firstly, it's necessary to comment that here we have 3 different levels of taxation, as I said: federal, state, and municipal. Federal, it's only 1 power, and the states, we have 27 different powers, because we have 26 states, and the federal district is the capital of Brazil, Brasilia. And in the level of cities, we have more than 5,000 municipalities, and each one charging taxes. Currently, there are more than 92 different taxes in Brazil, in both federal, state, and municipal tax. Different laws and understanding from the tax authorities to comply with, and it's possible to understand here that the problem in the Brazilian taxes is not only the matter of payment, it's the obligations and auxiliary obligations. So because of this, it's very complex. It demands a lot of energy from the taxpayers. We have a very complex system that demands accurate compliance of tax obligations. So once a friend of mine told me that only the Indian system is more complex than Brazil, and I believe that today Brazil is the worst one, because the Indian Federation approved a tax reform some years ago. So I believe that Brazil is the champion currently. Well, considering this contest, I prepared here a chart where is it possible to see a short information, or short summary regarding the main tax in Brazil. See that in the federal column, we have the main taxes created by the federal power, and I would like to highlight here the IPI, which is a kind of VAT, federal VAT, PIS and COFINS, which is a social contribution, and more than this, we have to highlight as well the income tax, the rural property tax, social security, and other kind of social contributions. In the state column, I believe that we have here the most complex and the most intense tax in Brazil. It's called ICMS. Why ICMS? It has this kind of bad idea about this tax, because ICMS is a very complex tax because it involves a lot of legislations. We have a federal constitution, we have a national legislation, which is a supplementary law. However, from these 2 different legislation, each one of the states, they create its own legislation. So we are talking about 27 different legislations. And because of this, sometimes we have different understandings involving the same issue of ICMS. And considering that we are talking about a VAT tax, we have to accept that in one state we have a debt and the other we have a credit. So all states are connected, and considering that in the same issues, sometimes you have different opinions from the tax authorities of different states. We have to understand that in this kind of situation, it's very complex for the taxpayers to pay the taxes and deliver the tax obligations, ancillary tax obligations. So because of this, I have to admit that ICMS is one of the most complex and of taxes in Brazil. And maybe it's possible to say that the tax reform will focus mainly in ICMS. In the state column, we have here the vehicle taxes as well, a donation tax, donation and heritage tax as well, and the other column we have the municipal tax, ISS, the service tax, which is very complicated as well. Consider that we have more than 5,000 municipals and of course legislations. We have the federal constitution as ICMS, national legislation, but each one of the cities, each one of the municipalities, they need to present or to approve its own legislation regarding ISS. The same for the real estate tax, IPTU. The other one, ITVA, we are talking about a transmission property tax. And the last column we called here others. Why? Because we are talking about contribution for a specific situation, and not necessarily you can say that it's federal, state, or municipal. It's only others, if you can say that. Here we have a summary explain that the main issues of the current tax system in Brazil. As I anticipated in the other slides, it's possible to say that our system is very fragmented. We have a fragmented tax trigger events. We have too many rates, benefits, and special regimes. It's in some cases of tax, there is they are cumulative. We have a high compliance and contingency costs. There is a study produced by the International Bank, the World Bank, saying that here in Brazil, we spend a lot of hours in order to comply with the tax obligations. So it's very difficult for the taxpayers in Brazil to deliver and send the tax obligations. We have here what you call tax war. And tax war, we are talking about ICMS. And why tax war? Well, it's very simple. Considering that we have different states, 27 different states, each of them wants to attract companies to its state. And how they will do that? Giving tax benefits. However, in Brazil, according to our tax, or better, according to our federal constitution, only with an agreement approved by every state, it's possible to grant tax benefits. But it's not a thing that all states observe. Why? Because normally they grant some tax benefits without disapproval. So, and in this context, we called this tax war. Recently was approved a legislation in order to end with this tax war. This legislation said that it's possible to validate these benefits under a certain limit of time, but after this, it will not be accepted. Different taxes as well. Let's see if they will follow this. Regarding income, we have a huge distortion here in Brazil. Consider that the economic situation in Brazil, we have distortion at the taxation of financial instruments and low competitiveness of investments abroad. So consider this, we have to admit that our tax reform is not necessarily only or better. The tax reform doesn't need to focus only in goods and services for a tax reform. It's necessary to include an income as well. Payroll, we have a very elevated taxation of the payroll, which is very complicated, and we will see shortly that it is one of the targets of the federal government regarding its tax reform or its project of tax reform. Possessions, we have to admit that we have low taxation rural states and efficient taxation of heritage and donations, and we have some problems regarding IPTO. So again, I believe that possessions, the problem I believe that the main problem is in regard to the heritage. Consider that the taxation is very low. Simplified system. We have a national law here saying that some companies under certain limits can use a simplified system, and because of this, it's possible to use it. But it's only a system applied for some companies under certain limit of revenues. So maybe only small companies is included in this. Okay. Well, once we understand how the tax system in Brazil works and understand that the complexity and how expensive is to pay taxes in Brazil, we are leading to a tax reform. I believe that we have been discussing tax reform in Brazil since the federal constitution was approved in 1988, so a long time. But I believe that since the last year we have a very good discussion and culminated in 3 different projects. There are some difference between them. I prepared here a chart in 3 different columns. The first one and the second one, we are talking about a project which changed the federal constitution. Because of this, is called PEC. PEC because it's a product of changing of constitution. And the last one is an initiative presented by the government, the federal government, and it's not a changing of the federal constitution. It's only a modification of the federal legislation. And considering these 3 different projects, we have to understand the difference between them. The first column, I believe that is the most complex, is more complex, and the second one, it's very similar to the first one, but it's less, it's more comprehensive, and maybe it solves some issues from the first column. Well, the idea behind the first one, the PEC 45, is to extinguish a number of taxes, 5 different taxes, and create just only one. The idea of this IBS is a tax over goods and services, and the idea is to have only one system for this. And the focus is only goods and services capable of generating the idea is to charge only goods and services. And this project includes the creation of a selective taxation as well. So a different tax. The idea is to create IBS and a selective taxation just in order to tax different products, and we call here, when we are saying here, which one generates negative consequence, for example, cigarettes. Well, focusing only in the IBS, the idea is to have a transition of 10 years, 2 of testing, and 8 transiting, a transition from one system to another one. different in comparison with what you have today. Only we have only uniform tax rate. It will include federal power, state power, and municipal power. So it's a tax administered by different levels of the federation. No tax benefit is granted here. So the idea is to end with the tax war, no tax benefit. So rates will be uniform. So all products subject to IBS will be taxed in the same way, 10% for every different products. They are saying that the tax rate here will be around 23% or something like that, in order to replace the other taxes. And why we have we will approve this kind of tax, consider that there will be no difference of taxation, or the amount to be taxed. In fact, for certain part of the economy, like the service sector, they will be more taxed with this IBS. But it's necessary, in the people who is defending this tax argue that it's necessary to do this because in order to simplify the system and transform the systems, simplify the system, and will make the taxpayers' life easier. So this is the summary. The second project is package 110. It's very similar to the first one, however, includes more taxes. The idea is to end with more tax than the first one. And the name of this different tax will be IBS as well. The selective taxation will be created as well, different tax again. The idea is to include income tax and social contribution too in this reform. Some part of the heritage and donation tax as well will be included in this reform. And the time for the transition is different, 5 years, half of the first one. Several rates fixed by the complementary law. Here we have the product includes less tax rate that we have today. However, they different in comparison to the first one. The product will state more tax rate because they believe that's necessary to respect different nature of some products and services. Benefits. The product ends with the tax benefits as well. However, the idea is respect some specific kind of situations, specific sectors of the economy. And more than this, the idea is to protect the free trade zone of Manaus as well. In the last column, we are talking about this is not as I mentioned before, is not a package because they will not, this project will not change the federal constitution, but it's a product initiative which change the federal legislation. They are saying that there are 4 different initiatives, and this is the first one to unify 4 different, to unify PIS and COFINS is the first one, and after they will end the IPI and IOF, creating an IVA, a VAT, a federal VAT. Well, there is no position regarding selective taxation. The idea is when after the VAT is created, will be approved the exception from payroll, change of income taxation, and there will be a single rate as well. And Manaus Free Trade Zone, there is no modification. So the more comprehensive reform will be the 1 and 2 columns. The last one doesn't include cities, municipals, and states. This is the thing, that only federal legislation. And once we have discussed the tax reform, I would like to present to you some measures which was adopted by the Brazilian government during the COVID contest. It's difficult to explain this because there was no reduction of taxation. In fact, only suspension of some deadlines. Suspension of deadlines. When it comes to suspension, I'm referring to payment of some taxes and extension of some deadlines to ancillary obligations, and in order to give to the taxpayers the opportunity to make the transitions to the home office and help them to adaptate this situation during this contest. Another very important extension was the validity of debt clearance certificates. And it's only a matter of documents, because this certificate is very important for the companies in order to participate, to attend, for example, a public bid, for example. Extension of tax payments, as I said before, simplification of procedures to present documents to the tax authorities, only ancillary obligations, so no reduction tax rates or only and different things in order to save money to the companies, only formal proceedings. Some rates were reduced, but it's necessary to understand that it didn't involve help to the companies. In fact, if you see here, we are talking about medical and hospital products. Some products used to combat COVID, specific products in specific rates, specific services in specific municipalities. The idea behind this reduction was to help the states buy products. So there is no explanation to keep the taxation when you have an emergency for this situation. The first one, the credit IOF, it was important because it involves the taxation of loans, financial loans. So it's important. I believe that this was a good news for the taxpayers. But the other one, it's possible to see that the target was products to combat the disease. One very important measure adopted during this period was that renegotiation. But it's a very specific situation when is not applicable to the companies which has with difficult to pay debts. In fact, it's a renegotiation of debts which was under a discussion, a judicial discussion. So the idea is to reopen some installments programs in order to include these debts. Suspension of tax debts protest. So it's important to have in mind that when you don't pay the tax in Brazil, it's possible to protest, and it causes a lot of problem to taxpayers, because if you have this kind of problem, normally you don't have we have a problem with loans or something like that. Suspension of procedures, deadlines, and administrative proceedings, only a matter of formal situation. You are discussing the administrative proceedings. So it's a kind of situation you are discussing a tax assessment, for example. State, ICMS and sanctions. I believe that here the target is again products in order to combat the disease. Social security measures. Well, there was no modification in the legislation of social security in Brazil. And normal social security in Brazil, it's an issue inside of the tax programs. And here there is a chart summarizing what they approved during this period. As the last chart, it's only a matter of extension of payment, extension of deadlines regarding the auxiliary obligations, and payments of some obligations. So no news regarding the changing in the tax legislation, only a matter of to help in some way the taxpayers. Here I include some highlights regarding the decisions rendered by the Supreme Court in Brazil. During this period, the Supreme Court looked to the number of decisions that the society is waiting, and they started to put the discussion in the table and start to decide. So I highlighted here two different decisions, and I'm referring to mainly to ICMS. It is what was very important decision because it's includes the tax war. And as I mentioned before, some states granted tax benefits without the approval. And in this situation, the discussion is if the state where is the buyer can cause or can deny the credit by the buyer. And the taxpayers allege that the state cannot do this because the benefit granted to the seller was not considered unconstitutional. But according to the Supreme Court, doesn't matter. If the credit is from an operation with tax benefit, the state of the buyer can deny the credit. So it's a huge discussion, a huge problem, but in fact, it was decided by the Supreme Court. Another very important decision was regarding the property, the tax over the transference of properties. And this is a situation very common here in Brazil when you use a real estate to transfer to a company in order to as a capital of the company. And the decision was, I know that there is an immunity according to the federal constitution for this kind of situation. However, if the value of the real estate is higher than the capital, in this situation, the difference is subject to the ITBI, this tax over the transference of real estate. The next one, we are talking about a specific situation applicable to the companies which are applicable to the rental companies. Normally here in Brazil, these rental companies, they buy cars, rent cars, and after some time, they decided to sell the products. And according to the tax authorities in Brazil, it's a kind of situation. It's a kind of situation equivalent to a sale of cars, and because of this, it's subject to ICMS as well. And the rental cars argues that no, it's necessary to pay ICMS because I'm selling fixed assets, and this kind of product is not subject to ICMS. So according to the the Supreme Court, the Federal Supreme Court, if the rental car sale the product before 12 months of their acquisition, yes, it's necessary to pay ICMS. Very important decision. I can highlight other decisions here, but the time is not enough to talk more about this. But I'd like to highlight the cases or decisions involving the energy sectors and export sections. Again, I'd like to highlight as well the decision regarding the most important issue or tax issue here in Brazil, ICMS, included in the calculation of base of PIS and COFINS. In fact, there was a decision. However, it's necessary to wait for a new appeal from the tax authorities. So the most important tax issue currently in Brazil, maybe it will be decided in the next year. And the last one is regarding software decision, decision in order to unify the understanding if software is a service or a good. And according to the majority of our ministers in the Supreme Court, is this product software is subject to ISS, service tax, and not ICMS, good service, good tax, or better, tax over goods. Well, but this judgment, this session was not ended, and because of this, necessary to the end of the final decision. But in fact, we have the majority. Consider that we have 11 ministers, and the majority of them has decided that yes, service tax is the tax. Well, I am the end of the presentation. Again,
도글라스 변호사님의 발표 감사드립니다. 이어서 간단하게 질의 시간을 갖도록 하겠습니다. 연사님께서는 답변을 영문으로 해주시면 감사하겠습니다. Obrigada pela apresentação, Dr. Douglas. Gostaria agora de abrir para Q&A. Eu peço que o Dr. Douglas responda em inglês, se possível. Temos aqui uma pergunta. Do you think tax reform will help to recover pandemic crisis? Also, do you think tax reform will go on right progress? Can you comment on this?
So thank you again for inviting me to present some tax issues in Kocham. Well, regarding the question, I don't know if the tax reform will be approved in time to help or to assist the recovery regarding the pandemic crisis. So I believe that not. It will take more time than the recovery of tax of the pandemic crisis. Anyway, the second question, also, do you think tax reform will go on right progress? Yes, I believe that is the target one for Brazil. I believe that is the one of the most important reforms in Brazil, given that the tax system in Brazil is very complex and very difficult to implement. So the three projects that is under discussion, they try to simplify the system. So I believe that it will be approved, but I cannot say that when and how how they will approve. So, but I believe that the tax reform is in the right way.
Obrigada pelos comentários e as respostas, Dr. Douglas. 그럼 코참 2020년도 법률 세미나를 마치도록 하겠습니다. 바쁜 시간 중에도 저희 세미나에 참석해 주신 회원분들께 감사드리고 다시 한번 이번 세미나를 준비하는 데 여러 도움을 아끼지 않으신 모든 코참 회장단 및 연사분들과 법무법인 관계자분들께 감사드립니다. 앞서 설명드렸듯이 본 세미나는 녹화되었으며 향후 필요시 다시 한번 접속하실 수 있도록 코참 파일에 기록될 계획이니 많은 관심과 지원 부탁드립니다. 모두들 어려운 코로나 위기 잘 넘기시고 연말 잘 보내시기를 바랍니다. 감사합니다. Com isso, encerramos nosso Seminário Jurídico Online 2020. Agradecemos a todos que se colocaram à disposição para estarem presentes no nosso evento online e, mais uma vez, reforçamos nossos agradecimentos para todos os membros da diretoria da Kocham, palestrantes, colaboradores das respectivas instituições dos palestrantes, para que este seminário pudesse acontecer. Como havia explicado no início do seminário, este conteúdo foi gravado e ficará arquivado na Kocham para que o conteúdo possa ser disponibilizado na própria plataforma da Kocham. Esperamos que todos se cuidem do coronavírus e que tenham uma ótima virada do ano. Obrigada.